Welcome to today's program titled, Are Your ERISA Fiduciaries in the Sights of the Plaintiffs' Bar for a New Wave of Fee Litigation? At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on a CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Ada Dolph. Ada, please go ahead.
Thank you, and welcome everyone to our webinar this afternoon. I'm Ada Dolph. I'm a partner in Seyfarth Shaw's Chicago office and a member of the ERISA Litigation Practice Group. I am joined by Ben Conley, a partner in our Chicago office and a member of the Employee Benefits Department, as well as ERISA Litigation team members, Sam Schwartz-Fenwick, and then Ian Morrison is unable to attend today. Next slide, please. Just a brief overview of what we're going to cover. We're going to talk about the history of ERISA fee litigation, specific signs that you or your plan are being targeted and why it's happening now, what we anticipate the litigation issues will be, and what you can do in the meantime. Next slide, please. Next slide. Okay, so ERISA fee litigation began, and I remember this day because it was the day I began doing ERISA fee litigation, was a single day in September 2006 when a plaintiff's firm came out and filed about 11 of these on the same day against very large Fortune 500 companies, challenging very much in sort of a cookie cutter fashion the fees that were being paid to service providers in then what was a new term to be used in this litigation, the revenue sharing. So that was one of the main focal points, but those cases evolved over time. What we have seen in recent years is a huge increase in the number of these cases being brought. And in part, that's because we have a number of additional plaintiffs firms getting in on the action, and they are targeting medium-sized and small plans that were not initially being targeted in the first few waves of this litigation. What makes these cases increasingly difficult, although there have been some bright spots here and there, is that 2 of the 3 complaints survive motions to dismiss. And because of the costly defense required for these cases, that often means you're put in a position of having to spend quite a bit in order to defend the case or to consider settlement at the cost of litigation. Next slide, please. What we've seen recently and why we're here today is we want to give you an early warning, essentially, about what we are seeing happening with respect to this litigation. We're seeing the fee litigation claims pivot toward health and welfare plans, which is an area they have not been made previously. So this just began in late 2022. We had a couple of different lawsuits that I'll talk about in a minute that began to look at understanding the exact fees that are paid to a third-party administrator, both insurers and claims administrators. These claims, as presented, could be readily expanded to include an employer because, of course, under ERISA, which we'll talk about in more detail, there's co-fiduciary liability. That is, if you're charging one of your fiduciaries that you're charged with monitoring with some problems in how they are performing their services, potentially you as a fiduciary could be held to a standard where allegedly you didn't monitor that service provider sufficiently. Next slide, please. So we'll talk in more detail again about these types of cases and the laws under which these lawsuits are being brought from a data perspective. Ben is going to talk a lot about that. But here's a couple of cases that we've seen, just the beginning of the pivot here toward health plans. So the first case is an insurance company challenge, and the plaintiff's firm in that case, and again, we've got 2 of these so far, well, 3. None of them are brought by the plaintiff's firm that has been the loudest, I would say, about focusing on health and welfare plans. So this first one is essentially a lawsuit that charged that the insurance company at issue was refusing to provide the data that the fiduciaries needed to assess whether the third-party administrator was adequately performing its services for the plan. So this case challenged the insurance company's refusal to provide an employer fiduciary with plan data, and they sought quite a level of detail, which would be required in these types of cases. They sought billed and excluded charges, allowed charges, paid amounts, diagnosis codes, claim codes, and other information. And the insurance company refused, saying that if they disclose that information, it would expose confidential discounts and payment contracts with providers, which they consider proprietary information. This lawsuit really focused on the data and said, if we get the data, then we suspect that there is a breach of fiduciary duty here, but it really didn't come out and allege that in any great detail. It was very focused on the data. Potentially for that reason, the judge ordered the parties to really focus on resolving the claim. So they mediated multiple times and eventually reached some resolution around the data, and this case was dismissed, voluntarily dismissed. Next slide, please. So in the context of a claims administrator, this case has been brought in the Northern District of Texas. It's quite new. We don't even have on the docket yet a response to the complaint, but it's similar in terms of the prior allegations that we talked about. But this one goes further. It says, from the data we've obtained, even though incomplete, we can conclude that there are breaches of fiduciary duty. So the main charges, based on the limited amount of data that they allege they received, are that the claims administrator approved fraudulent claims without first determining whether the claims were legitimate, and then failed to recover payments made to those same providers, and then pointedly alleged the claims administrator had a different level of claim scrutiny for claims that it fully insured versus this employer's self-funded plan. But again, it only has partial data. But this complaint went much further in terms of alleging breaches of fiduciary duty. And what's interesting is it's brought by, an employer who is anticipating or trying to get ahead of issues I suppose they anticipate in the service provider arrangement that they have. Next slide, please. The other thing I would add is that we've seen some developments in the ERISA class action sphere generally that will impact this litigation going forward, as well as fee litigation, that are worth mentioning. So the first is this Bugielski, and everyone differs on the pronunciation case, that came out of the Ninth Circuit very recently. It had a very literal reading of 29 USC section 1106, which governs prohibited transactions, and essentially means that anytime you enter into a contract with an entity that has some prior arrangement or relationship with the plan, that it could be considered a prohibited transaction. And this, we believe, is going to be very difficult from a litigation perspective, because almost right out of the gate, you have a prohibited transaction because, of course, many of these contracts are revised, amended, and the like with service providers that have provided services to the plan in the past. And under this ruling, those would be encompassed as a prohibited transaction. So we've talked about this case as a little bit of a catch-22. Obviously, as prudent fiduciaries, you need to be doing requests for proposal, making sure you're monitoring what's happening in the market. At the same time, if you enter into a contract with a service provider that you have a prior relationship with, or that the plan does, you're in this territory of being alleged to have a prohibited transaction that would survive a motion to dismiss. Seyfarth participated in an effort to get a rehearing on this case and have the Ninth Circuit take a look at it. Unfortunately, that petition for rehearing en banc was denied last week. The one bit of good news I can report, though, is that this morning, a judge in the Second Circuit issued an opinion, which is much more consistent with what we've seen in the Third, Seventh, and 10th Circuits, basically saying there has to be something more than just the transaction between a party in interest and the plan. And its specific opinion on this point is that a prohibited transaction claim based on money paid to a retirement plan service provider must include allegations that the services were unnecessary or that compensation was unreasonable. This, we believe, incorporates much better the actual language of ERISA and puts defendants on a little bit more of an equal ground with plaintiffs when they're bringing these cases. This will be very helpful when we're dealing with the same types of claims in the health and welfare sphere. The Ninth Circuit will probably continue to be difficult in that regard. Now I'll pass it over to Ben.
Thanks, Ada. So next we want to talk a little bit about why we think this is happening now. Because, health and welfare plans have been around, subject to ERISA since 2006. But by and large, while we have seen some very limited, narrow, targeted class actions in the health and welfare space, they've been more peripheral and less directed toward the cost of services, right? So with that in mind, there have been some pretty sizable developments in the last couple of years that derive from really two sources of law. One was the Affordable Care Act, which has been around for a long time, but had sort of a latent provision in it that allowed the government to create new regulations that would usher in an era of fee transparency in health plan costs and guidelines. And those regulations were issued under the Trump administration. Right around the same time, Congress passed a law in late 2020 called the Consolidated Appropriations Act that did a lot of things, but one of the things that it did was layer on top of new and sometimes overlapping transparency guidelines that also apply to health plans. And over the last 12 to 18 months, what we've seen is the Department of Labor, Department of HHS, and the IRS issuing guidelines that implement these provisions. And I'm going to walk through what each of them are. Hopefully those of you on the administrative side of the house are familiar with these because these are all in effect. But these share one common theme, which is that they remove barriers to access to health plan data, right, where they previously existed, where health plans historically have not really had meaningful access to provider agreements, payment rates, quality of care data from health plan providers and via your third-party administrator. And then number two, they require that information be made publicly available, which is kind of a big deal. In the ERISA space, we're all very used to participant rights and participant ability to request information related to the plan document, information relied upon in determining a claim for benefits, et cetera. But this sort of public availability, if you will, is sort of a new angle. And we have suspected for a couple of years, ever since this law passed, that while this could be used for the purposes, what we think Congress intended, which is to sort of change marketplace behavior, we also suspected that this could be grabbed onto by plaintiffs' attorneys to make the types of assertions that Sam is going to talk about in a moment. But the four provisions, and these are very high level overview, are number one, ERISA has always had a provision, ERISA 408B2, which historically is only applied on the retirement plan side, which generally requires that vendors providing services to the plan provide data on the fees that they are assessing, both via direct compensation and indirect compensation. The Consolidated Appropriations Act required that for any new contract or renewal, vendors, specifically brokers or consultants, disclose direct and indirect forms of compensation they are receiving. In the marketplace, we have seen many vendors interpret this as only applying to sort of traditional insurance brokers, but the regulatory guidance to date, which is informal FAQs, is actually much more expansive and probably oftentimes would be deemed to extend to health plan third-party administrator and or pharmacy benefit manager managing your prescription drug benefits. So what that does, and by the way, common theme here, all of these requirements actually apply to most directly to the plan sponsor, the employer plan sponsor, which is odd because it's not employer plan sponsors who have historically been saying, don't give me the data, I don't want it, right? This has sort of been a market practice driven by vendors primarily. But what all of these do are essentially regulate the plan sponsor and say, you have to get this data. And the idea there being, and we've heard this from Senate aides, et cetera, just jurisdictionally, it was easier for them to regulate plan sponsors than it was for them to regulate vendors. But what these effectively do is say, plan sponsors, you have to get this data so that if vendors want to remain in the marketplace, even though they are not directly regulated by many of these laws, they sort of have to comply because otherwise they'll run out of clients, right? So that was the first one, the fee disclosure. Second one, and this is a novel concept, but really shouldn't be, is that health plans have to create a price comparison tool. Again, I said there's two sets of rules coming out here. One was price comparison tool. The other was an advanced explanation of benefits or EOB, but they both share the same concept in that participants should be able to determine how much a health plan service is going to cost them before they go and get that service to effectively drive consumerism in health plan consumption, right? Which again makes a lot of sense. Oftentimes these medical procedures could be one of the most expensive procedures that anybody could, pay for in any given year, or cost for that matter. But historically, employees haven't been able to find out how much the service is going to cost before getting it. And employers who are ultimately the payers in this circumstance haven't been able to figure that out either. You just find out later when you get the bill. So again, price comparison tool where the person is able to go in and enter the service they're going to get and where, and be produced a highly customized estimate of what that is going to cost them, specific down to the level of where they are in the deductible and their out-of-pocket maximum. The third thing, and this is kind of a big one, is that, and this applies, by the way, to hospital systems and health plans alike. All of these organizations are required to post reams of data on publicly available websites disclosing both what the health plan has contracted to pay in the in-network setting for a certain designated list of services, as well as what the health plan has historically paid out of network over a rolling period of time for, again, a designated set of services. So again, obligation applies directly to the health plan or health plan sponsor, but facilitated obviously by the third-party administrator because that's who really has all of that data. And these are on the internet, right? You can go find these now, in theory, for any hospital system or health plan. Sometimes they can be hard to dig up. As a human, because you are not a machine, you will not be able to read it yourself, but if you have the proper software, you can dig in and interpret what this information is, down to a very specific level of what a specific health plan is paying for services over time. And then the final one, and this is perhaps the most important one to facilitate all of this, is a new requirement that health plans, and specifically employer health plan sponsors, not enter into a network or provider agreement that contains a gag clause that would restrict the flow of price or quality of care data or de-identified claims data to that health plan or to a third-party administrator for purposes of health plan administration. Because again, you couldn't do any of these things, right? The machine readable file, price comparison tool, et cetera, if the contract has a term that prevents you from accessing that information. So that's the big one that in theory removed the barrier to access to that information. And this is kind of what a lot of the lawsuits that Ada was talking about earlier surround, is that gag clause prohibition, because even though this has been in effect since late 2020, health plan TPAs, networks administrators, claims administrators, I mean, this has historically been their business, right? They develop a network, but it's proprietary and confidential what they're paying in that network, so they can, maintain a competitive advantage over similarly situated network TPAs, claims administrators. And they have to adjust, and we're seeing adjusting based on the cadence of these lawsuits. But it's all kind of new because they're now being pushed on it, right? For the first time. No, we can't have a gag clause legally. We have to be able to have access to this data. And by the way, we want to exercise our rights because we no longer have these gag clauses. We want to gain access to this data. So those are the four provisions that facilitate this. And Sam's going to talk about how that comes into sort of the theories of what we expect plaintiffs' counsel may bring in this setting. But if there was any hesitation or question as to whether plaintiffs' counsel are moving into the space, we'll dissuade you of that if we can move to the next slide. And Sam and Ada know about this far more than I do, but there is active solicitation happening from prominent plaintiffs firms, and probably the most prominent in the 401k fee space, Schlichter Bogard, who filed the 11 lawsuits that Ada was talking about back in 2006, has been soliciting specific individuals, named plaintiffs from specific companies. We've redacted this one, but there are named companies that they are soliciting plaintiffs from, and there are companies where they have found plaintiffs, right? We'll talk about why we know that in a moment. If you can go to the next slide, you can also just Google around a bit and find various articles interviewing Schlichter, where he names the companies that he has targeted or that are in his site. And as we understand it, it's an ever-growing list. Most recent article, first one was 10 companies, second one was 14, and the most recent I saw had even more. So he has, and initially he indicated that there was something in common amongst these organizations that made him choose them for potentially, bringing these class actions. But subsequent articles did not indicate that. So we're not 100% sure how he's picking and choosing his potential targets here. But he clearly does have potential targets. If we can go to the next slide.
And I just want to add
Yeah,
anecdotally that in depositions of named plaintiffs in these cases, almost to a person, they say that they felt there was nothing wrong with the plan until that ad popped up, suggesting that there may be something happening at the plan level that they were not aware of. So those advertisements can be persuasive to a layperson who's not familiar with how this litigation works.
Yeah, absolutely. And again, companies being targeted here, perhaps no surprise, are large companies, right? So the ads are reaching out to all plan participants. So you're talking about, for some of these organizations, pools of hundreds of thousands of people. And they really just have to get, Ada and Sam can tell you this, but really just have to get one or a couple to start the ball rolling on a potential class action. So the reason we know that he is serious is because organizations have started getting what we would call a 104B4 request under ERISA. And ERISA 104B4 essentially says any participant in the plan is permitted at any time to request the plan administrator to provide a series of data, right? Plan, SPD, Form 5500, other documents under which the plan is operated. And that's what we've seen, is that this law firm has sent a number of different employers specific requests saying, hey, we want, I'm writing on behalf of a participant in your plan, which is important because that's the only person who can request that information, a participant or their authorized representative, a series of information from your plan. And so the ones that we've seen, and we've now seen a couple of them, and they're all about the same, request the plan document, SPD, and Form 5500, which again, all valid requests under 104B4. the administrative service agreement for any vendors facilitating administration of that plan. So, that's going to be your claims administrator, your network administrator, your PBM potentially. Come back to that one in a minute on whether that's a valid request. And then finally, the new one that we've never really seen in 104B4 requests before, but it's kind of a new thing, is information on the plan's price comparison tool and how it was conveyed to participants. So again, you'll recall that when I was talking about the new provisions of the CAA, one of them was this new price comparison tool where you can type in, I've got to get the service from this doctor, what's it going to cost me? So that is a requirement under the CAA that the price comparison tool be made available to participants. But the CAA is a little sort of hazy on how that's conveyed to participants, right? So, it doesn't appear that it's required to be in the SPD. There's nothing in you have to tell participants about it and where it is, but there's not really indication of how you do that or when. And I think there's probably some uncertainty regarding whether that's a valid 104B4 request. But, again, you have to have it out there. You have to make it available to participants. So I think it would be hard in this context to say, we're not going to give you the price comparison tool because it is a plan participant, right? They're entitled to it. One administrative point, then I want to come back to that service agreement piece. Any request under ERISA for documents requires that you respond within 30 days. If you do not respond within 30 days, there are potential statutory penalties that can be applied by a court of $100 per day. So that could get expensive if you delay for a period of time. Also, if you accept the premise that this is a precursor to litigation, which I think we're all sort of reasonably assuming based on the track record of some of these firms, it can also just look bad, right? If a participant sends you a request for this information and you just disregard it. Now, oftentimes it's not intentional disregard. We have seen many times over the last several years that COVID has disrupted the regular flow of mail services, right? And things get redirected. People have relocated to different places. People are working remote, and it's very common that a piece of mail can sit on a desk for 3, 4, 5 months without anybody picking it up and opening it. So you are going to want to make sure that you have a good process for the people in your organization who may be plausibly receiving these requests, which most directly would probably be the person designated on your Form 5500. That's oftentimes where a participant or plaintiff's counsel will designate or identify someone to receive this information. That there is a good process for checking that person's mail regularly so that you can timely respond to these types of requests. And that whoever's going to be opening and looking at that mail understands the importance of these types of requests, right? Because again, it starts a clock, and if you fail to respond in a timely fashion, looks bad, but it can also cost you potentially a lot of money. And then final point, it does probably make sense if you get one of these letters. Look, 104B4 requests come a lot on a variety of things. Some of them are routine and non-threatening. Others are more threatening, like a letter from a notorious class action ERISA litigator. For this one, at least, it might make sense to try and get your counsel involved earlier rather than later. For instance, the request at issue in our circumstance covered a 6-year period, right? So, which is sort of the statute of limitations under ERISA. There's some nuance there, but statute of limitations under ERISA clearly covering a broad swath of time. Technically, under ERISA, under 104B4, you're only supposed to provide the most recent documents, unless it relates to a specific claim from, say, 2021, and that's what the person's asking about. But that can provide some avenue to be responsive, as you are required to be under the law, but not more than that, where you're giving a lot more information that you don't otherwise necessarily need to produce in that circumstance. Similarly, oftentimes these requests are pretty generic, right? And give me all, and what we know is like health and welfare is a very generic term that could encompass a lot of different benefits. So there are some avenues or potential ways to sort of draw the parameters of what you are responding to and why you are responding, and leaving the door open that if they have a specific request as opposed to just a fishing expedition, they can clarify that and get more details. And then the final point is like, what's a 104B4 document? Again, I mentioned plan document SPD, and then there's also this amorphous other documents under which the plan is operated or governed. our stance is typically that a service provider agreement is not that, right? First, it's not listed specifically under 104B4. Second, I think if you would ask most plan sponsors, they would say, we have engaged a service provider pursuant to a service agreement, but we've directed them to follow the terms of our plan. That's the operative document, right? The terms of our plan, not our service provider agreement. And as a result, that is not a responsive document under 104B4. Now, look, as Sam, I think, and Ada will talk to you about in a minute, that doesn't mean that this information may not eventually come out, in a class action. But this is all sort of what are you laying out on the table at this stage, and that's why we kind of think it's important to be strategic about how you respond to those requests. If we can go to the next slide. There are also some other potential things that participants may request at this stage. Again, these are things that aren't necessarily under ERISA 104B4 because when ERISA 104B4 was drafted, none of these new laws existed. But just beware that there are other things out there that could potentially come up, like a link to the machine readable files, right? That's something, those files are out there. Typically, the link is maintained or housed on your third-party administrator's website, but you're supposed to tell participants how to be able to get access to that. Public is also able to access that information. So that's a request you might see. We talked about the price comparison tool. The other big one that is kind of ruminating out there and not really seemingly the focus at this point, but could potentially become more prevalent down the road and has sort of come up a lot in single plaintiff cases is under the Mental Health Parity Act, the non-quantitative treatment comparative analysis, which is essentially an analysis your plan is required to perform looking at all of the so-called non-quantitative treatment limits under your plan. So soft limits, not hard and fast dollar limits, but things like prior authorization requirements, medical necessity standards, network admission requirements. It's essentially an analysis looking at all of those that exist in your plan and detailing why you think that is treating mental health and substance use disorder benefits no more restrictively than medical or surgical benefits. So again, things that could potentially be a valid request even outside of ERISA 104B4 to keep an eye on. Those may be coming up as well, although we haven't seen those other than the price comparison tool to date. So with that, I'm going to hand it to Sam, who's going to try to prognosticate. I think this is an important point, right? None of these lawsuits have been filed, to our knowledge. There have been some employer lawsuits filed against their TPAs, but to our knowledge, there have been no class actions broadly indicating that in the health and welfare space, a fiduciary has breached their fiduciary duty because they've failed to, Sam's going to tell you what, right? But let me pass it over to Sam, and he's going to talk about what's going to come up there.
Thanks so much. And if you could skip ahead to slide 18. So it's kind of a fun webinar that we've put together, because if you think about like the stereotypical lawyer as, an overly anxious person, we're really giving you one more thing to worry about, because we're talking about lawsuits that haven't even been filed, but nonetheless, embedding scary thoughts in your mind, so you can think about those when you're trying to sleep tonight.
But Sam, unlike most of our warnings, we really mean this one, right? This one is
Yeah, I mean, let's be frank. These lawsuits are coming. They could be filed tomorrow. They could be filed in 6 months. But the Schlichter firm, if they're going to go out and as publicly as they have start soliciting for participants to be named plaintiffs in a class action, they're going to move forward. And I think what we've really seen so far with the litigation that Ada's talking about, where plans are suing their third-party administrators, that's laid the groundwork that this is potentially a fruitful area of litigation. As we're going to talk about in a minute, when these claims are brought, whatever their specific theory, there are going to be arguments that we can raise against them, and we think we'll have strong legal defenses. That said, I think it's hard to, or you can't deny that an area where courts are going to be very sympathetic is to the claim that healthcare costs are out of control. And if these lawsuits are trying to control healthcare costs, judges are going to try to fashion a way to allow them to survive motions to dismiss. Law be damned. So that's just an important thing to think about. So obviously we don't know exactly what plaintiffs are going to argue. That said, we have a good sense, because if you look at the fee litigation that's been taking place over the past 20 years and as it's evolved, inherent within these claims is that plans are contracting with service providers at rates that are too high and then not paying enough attention to what the actual costs are. So it's, a failure to monitor, which is part of your fiduciary duty of loyalty. It's also, a failure from the onset to take a really hard stance and make sure that the rates you're paying are reasonable in the specific marketplace. So we think that in both those areas, plaintiffs will try to apply them at least to the retirement or to the welfare plan space, arguing that the cost that the plan is paying for certain procedures, the negotiated rates it's agreed to with the third-party administrator for processing claims are inflated and too high, and that you need to find a way to lower those. We think that one of plaintiffs' theories is going to be very aggressive discovery, both of the plans themselves and their third-party administrators for the underlying data, in order to try to look under the hood, you could say, to say like, okay, this TPA is suggesting that its fees are X. But really, if you look at, all the other maybe payments it was receiving from certain vendors by doing things such as not going after certain claims of, mispaid benefits or cross-plan offsetting or all these things, that the total cost is actually higher. And so that was inflated. Or an argument we've seen them make of late in the retirement plan context is just to nakedly argue that the profits made by the third-party administrator are unreasonable. We think that these theories dovetail pretty clearly, not just with breach of fiduciary duty claims, but also with a prohibited transaction claim, that people are being paid more than a reasonable rate for the services that they're providing. The reason we've been watching that Ninth Circuit case against AT&T, it's the B case with lots of consonants, is that, it sets a standard that there is no standard for allowing these claims to survive a motion to dismiss. The mere fact that you have an agreement with a service provider that's been renewed allows a claim to survive a motion to dismiss. It's heartening to see other courts not adopting that doctrinal view as of yet, but we still think that that's going to be an argument that plaintiffs are going to continue to push, because it's very tantalizing for plaintiffs to be able to raise an argument that's virtually immune to a motion to dismiss. So we do think on the self-dealing point, they're going to be trying to, if they survive a motion to dismiss, they're going to be trying to get a lot of discovery that's getting at what are the, what is the total view and as broad a definition as possible of the way third-party administrators are benefiting from their relationship with the plan. Again, Ben mentioned a few slides back how the law in the welfare space, it's increasingly, it's always been document heavy in terms of what you are required to produce, and that's just becoming more and more onerous over time, which means that plaintiffs are going to try to nitpick at the margins to say how whatever disclosures you've done have somehow been deficient. It might be that the 408B2 disclosures to the, regarding fees are not as all-encompassing as plaintiffs think, to something as, the link you provided for people to look at transparency issues is a dead link. And so we've been harmed by one or many of these issues. And the risk and why it's valuable for plaintiffs to make these arguments in ERISA is if you prevail in whole or in part on any theory, you get attorney's fees. So it's very valuable for them to make these seemingly small, narrow claims because, they're for-profit businesses, even though they're trying to attack third-party administrators who are also for-profit businesses. And so they want to figure out, the lowest common denominator to make money, and that is trying to nitpick on the margins. So those are things generally to watch for. Let's go to the next slide to talk about defenses. So the best defense that we have, or one of the best defenses that we have for these types of anticipated claims, is a 401k plan is not analogous to a welfare plan. In a 401k plan, you have your account and you will be charged fees in that account based on plan administration and also the investments you select. You don't have an account in a medical plan. Your obligation is, as a participant, is to pay a set fee, either for you individually or for your family. And because by paying that, you're then eligible for covered benefits under the plan. And for that reason, it looks a lot more like a defined benefit plan. Now, we anticipate plaintiffs will try to get around that by saying that there are deductibles and that potentially if you had done, if the plan had lower negotiated rates or things like that, you might not have eaten up your whole deductible. That's a potential argument. It's also pure speculation and very hard to make that on a class-wide basis. We think the stronger argument is just these claims lack standing because there's no injury. People paid their plan premiums and they received exactly what the plan promised. Now, it's possible that the company, as the plan sponsor, might have paid more than it needed to if it could have negotiated lower rates or things like that. But that doesn't state an injury to the participants. And there's a really strong case called Thole out of the Supreme Court on standing, which the holding of Thole is, if you're just noting that an injury to the company, that doesn't, as plan sponsor, that doesn't state an injury to you as a plan participant, as long as you received your full benefit. And so we think that line of argument is going to be very apt and on point. But if it does get past the motion to dismiss stage, we think some core arguments are going to be to really look at what is a fiduciary's duty. And a fiduciary's duty is to negotiate, in this case, it's to negotiate and agree to service provider rates that are reasonable, given the complexity of the work based on, what's available in the marketplace. Plaintiffs will be hard pressed, in our view, to find, an analogous service provider who was offering comparable services at a lower rate. We can also make the argument that it really goes against 50 years of ERISA litigation, as well as, the whole system of the United States, to try to bring a legal claim challenging a business's ability to make a profit and looking not at, what they charge and the rates charged, but the profit margin. That there really is no precedent for that, and it's really improper, especially because fiduciaries don't have that information or knowledge. They know if they do an RFI, they know in response what the fees they're told it will take to provide these services, and that really should be how you establish reasonableness. We think another defense, and we'll get to this in a second, is to show that whatever the ultimate fees paid were, they were the result of a reasoned and prudent process. Now, ERISA does not require you to pick the cheapest rate. It requires you to have a reasonable process in terms of selection. And there can be a lot of reasons other than cost that lead you to go to a service provider. So these process arguments we also think are going to be really significant. I want to flip to the next slide so Ada can talk about, before we get to these merits decisions, other options we hope will enable these cases to get kicked to the curb if they do survive motions to dismiss.
Okay, so talking about potential defenses and ways to prune down a class, which inevitably will be sought in these cases. So on the retirement fee litigation side, we've seen different interpretations of the Thole case that Sam was just talking about. And there's a circuit split right now about how much standing a named plaintiff needs to have to represent a class. For example, in the retirement plan context, is it enough that the named plaintiff invested in the same plan? Or do they need to have invested in each of the investment options that are being specifically challenged in the complaint? And the courts have come out differently there. Obviously, from a defense perspective, we're arguing that the person trying to represent the class was not harmed in the same way as the class, and therefore does not have standing to represent those that have been. Those arguments, as I said, have been a hit or miss, really, on the retirement side. We expect to be able to make a lot more individualized arguments, sort of going off of what Sam was talking about, in the welfare space. Obviously, each individual has its own unique set of claims that they've sought, their own potential deductibles that they've met, their own providers in different networks, in network, out of network. There's a whole number of different ways that we can talk about that class certification would be inappropriate, that class treatment of all of these participants together simply can't be done. We also have seen from the WIT line of cases, I think, some of the barriers to trying to find remedies for these kinds of cases. And that's also a component of class certification. Is the class treatment the best way to provide the remedy to the class member? In the WIT situation, there's been some orders to redo the claims process for a number of participants, and that has proved unworkable in various different ways. So we expect to make some very strong arguments in this space. Again, however, with ERISA, there's a certain amount of similar treatment across the class that courts typically look to and feel comfortable certifying. But this will be new territory, and there's, I would say, a lot more individualized decisions that could preclude class certification, or at least whittle it down to match whatever named plaintiff you have in front of you. And back over to Sam.
Oh, Ada, why don't you first do the CLE code?
Excellent. Thank you, Sam. Okay, the CLE code is SS, as in Seyfarth Shaw, 6733. That's SS 6733.
Thanks, Ada. Donna, if you could flip to the next slide, and then one more as well. All right, fabulous. So what should you do now? We think that, you could rest on your laurels and wait for, judgment day, or here, the day of service to arrive. That's not our recommendation. We think that now could be the time to really take a close look at your processes for decision making in the welfare space and start developing your defense right now. We would recommend working with outside counsel in doing this so that you can maintain privilege over this analysis. On the 401k side of the house, and in large part because of 20 years of litigation, most retirement plans at this point have very robust express processes in place with quarterly minutes, presentations by independent third parties, record keeper presentations, outside counsel talking about trends. There's a lot of process that's in place on that side. And while some welfare plans do that, historically things have been a lot more lax on the welfare side. And that makes sense for a lot of reasons. You're not making investment decisions. Other than when you're negotiating contracts with TPAs, there hasn't been as much regularly to do unless your fiduciary committee is also charged with deciding final appeals of claims. Because those processes haven't been in place in the same way for many plans, that means that it's harder to go to a document repository like minutes to see what the decisions of the fiduciaries have been and why. That doesn't mean there haven't been well-reasoned decisions. It doesn't mean there hasn't been an excellent process. What it does mean is you have to dig a little deeper and probably need to have meetings with decision makers and persons with knowledge to learn about that process and to figure out historically how decisions were made. We think that it's really helpful to have that in place as soon as possible so that you can be in the best place possible with your fact gathering when litigation comes. It's possible that as a result of this, you might realize that, hey, there really doesn't seem to be a process in place. If that is a takeaway, it's really important to discuss with counsel whether it makes sense to proactively put in place a process. The risk of doing that when you think you might be sued is that it can be spun as some kind of admission of guilt for all the time before you put that process in place. So you want to be really careful before you make any forward-going changes. But that's an example of, it might make sense. And that's why you want to have counsel involved as well. In addition to the decision-making process, key things you're going to focus on are any documents relating to an RFI or RFP, any facts that you might have that might exist regarding cost discussions with your TPAs. Those are all really important things to look at. Ben, I wanted you to talk about that last point.
Yeah, so important point here, which is, as Sam mentioned, we have not seen the lawsuits being filed yet. But it is very important, especially as you go into 2024 contract renewal, to put yourself in the best position possible without regard to what those allegations are at this stage. So what does that mean? Make sure that you have adequate access to data in your contract, right? No gag clauses, proper allocation of who owns data and who has access to data. Importantly, pricing information. You're going to want to make sure that you have a good understanding contractually or otherwise of all the fees that your service provider is charging you in that regard, and full transparent pricing disclosure there. It's important to make sure that you have checks in place to be able to make sure your vendor is performing well. Those could include things like robust audit rights or service level guarantees on the performance that they're doing. Inherently, you don't want a contract that's too long from a term perspective without adequate termination rights for any reason if you can get it, but certainly if fiduciary circumstances dictate that you may need to terminate. And then just, it's important to understand that your service provider is often serving in a fiduciary capacity. So you want to have ERISA fiduciary standards of care that apply to the services they're performing. I think this is a big oversight in the welfare space, but the establishment and vetting of network providers, you aren't doing that, right? You are relying on your network administrator, your claims administrator to do that. So perhaps a representation in the contract that they understand that you are relying on them to fully vet providers, negotiate preferred pricing, et cetera. So that's just a highlight of some of the things that we think are important. But again, we think it's very important to get those in sooner rather than later, because as these lawsuits start getting filed, you may be locked out of, data requests until you re-renew the contract.
Thanks, Ben. If we could go to the next slide, and I'm being conscious of the time. So one important thing to remember is the need in this pre-litigation period to be really careful about how you discuss the threat of litigation with your decision makers. Under ERISA, until there's an actual threat of litigation or a lawsuit is filed, discussions you have with your fiduciaries are not privileged, because the thought is the advice you're providing is in the service of the participants, so the participants are entitled to view those documents. Because of that, we think it's really important for your decision makers, to keep doing the normal work they're doing, obviously, and to think about the emails they're sending with an eye towards how would I feel if this email was shown to me in a deposition. Often adding that little nudge to people is all it takes for them to take an extra 30 seconds to read the email, tone it down, get rid of some colloquial speech, and more clearly say the issue in a less inflammatory way. We suggest having that discussion orally with your decision makers, and just reminding them of the need to just be thoughtful in what they say while continuing to do their best job for the exclusive benefit of participants. This is a good area where you might want to work with counsel to make sure your talking points are on point for that before you move forward. And then let's go to the next slide. And this goes to one of the questions that I saw that we had. It's asking, do we think companies are going to sue third-party administrators? Well, so we have seen some suits in the past year. And it's possible that in response to information request letters, a company might sue its third-party administrator. It's important to be really thoughtful before you make that decision for a few reasons. One, you probably do not have a ripe claim if you just file suit. You have to go through a process with the third-party administrator, try to get information from them, wait for them to respond. It can take 6 months to a year to be at a place where you would even arguably have enough information to file suit. Then, even if you do file suit, after you've received an information letter from plaintiff's counsel, they're going to view that almost as an admission of guilt. Like, look, our letter telling you you were paying too much for fiduciaries or, for these vendor services led you to sue the vendors. So we're right. So we get, give us the money. That would be their theory. And it's important to remember that just pointing the finger, and this is really what's critical, is pointing the finger at your vendors for overcharging doesn't absolve the fiduciaries of 100% liability. Under ERISA, each fiduciary is 100% liable for their breaches and co-fiduciary breaches if they also had a role in those, or could have had a role in those under the contract. So pointing the finger at a vendor in this context is akin to conceding that you breached your fiduciary duty, or we think it's very likely that's how it will be perceived. So we would strongly suggest that you work very closely with legal counsel before pulling the trigger on any strategy that went down that path at this time. And I see that we're out of time. It is right at 3 o'clock. Thank you so much for your questions and participation. And please feel free to reach out to us. Ada definitely has the easiest email to reach out to. Mine is atrocious, but please reach out to any of us, and we're happy to put our heads together and get back to you as soon as we can. So thanks so much.